Well, good morning to those of you who are in Brazil, and good afternoon to those of you who join us today from the UK. As our tax committee of the Brazilian Chamber has informed us recently, a new law dated 15 of June 2023 has enacted the adoption by Brazil of the so-called arm's length principle in transfer pricing, hence aligning domestic rules to OECD standards. As we know, transfer pricing rules are of crucial importance to multinational companies operating from one country to another, carrying out business, trade, and finance amongst parent companies, subsidiaries, and affiliates in different jurisdictions, due to corporate tax adjustments that are applied aiming at a more evenly distributed taxation. Brazil's system had long ago been identified as non-aligned with international practice, which, together with the perception of its inadequacy, has led to the decision on the part of the Brazilian tax authorities to review it and modify it, with an ultimate view of avoiding excess taxation as well as tax evasion. This was by no means an easy task, but now it is a concluded task and one that is very important for the modernization of the country's tax system.
Hi, Vera, I lost you.
Gustavo, you are muted.
Gustavo, you are muted.
Thank you. Let's wait for Vera, but in the meantime, if I may, just a couple of housekeeping rules, asking our participants to keep the microphones mute.
Okay.
Vera, welcome
Look,
back.
I think, yes, thank you. I think that something happened here, but let me carry on. As I was saying, we are very grateful to our tax committee led by Gustavo Braga, founding partner of BBS, Braga Bastos and Sá Advogados, for putting together this webinar where we will hear from tax specialists on this new and important law on transfer pricing in Brazil. So to our tax committees, as well as to all of our speakers today, our sincere thanks for organizing this webinar and for sharing your knowledge with you. So finally, as I always do before I ask Gustavo to start, I would like to say a few words on our housekeeping rules, which are the following. I would ask you please to keep your microphone muted and your camera switched off during the webinar. There will be a Q&A session today, and questions can be asked via the Teams chat box. So please feel free to type your questions and send them over to our speakers. Also, please note that this webinar is being recorded and that the recording of this session will be posted at the Chamber's website and social media in the next few days. So with that said, thanks very much again, and over to you, Gustavo.
Thanks, Vera. Of course, thanks to our panelists, and thanks everyone attending today. And well, I'd say a very special thanks and congratulations to the Receita Federal officers and the lawmakers that made this very important change happen. We all know in the globalized economy we live in, countries face fierce competition for investment. Converging tax practices to global standards means enabling both increased legal certainty, which is the holy grail for productive investment, and increased tax revenue, including from collaboration among tax administrations and from cooperative compliance with taxpayers. It's already been noted that these new Brazilian TP rules, moving away from statutory margins and embracing comparable uncontrolled prices as grounds for adjustments, if any, they bring about a new paradigm. They do require a change of mindset. So may the enactment of these new rules, the convergence they represent to global standards, as well as this dawn of an enhanced relationship among stakeholders, be a beacon of light into the panorama of Brazilian taxation. New tax rules always bring about uncertainty in the beginning, likely even litigation, until the interpretations are settled. This is why we're very privileged today to have with us such renowned specialists in this field. Kim Allen, Head of International Tax at BTG, Márcio Oliveira, Partner at EY and its TP Leader in Brazil, and Francisco Lisboa Moreira, LLM, Partner at Alma Law in Brazil. Despite the vastness of the subject, we'll have these experts addressing some focus points for interpretation of the new TP rules and their implications in practice. And since the buzzword for today is the application of arm's length principle and convergence to OECD standards, let's begin our technical session learning about the United Kingdom experience in those areas and the mismatch and pitfalls this may imply. Kim, would you please?
Thank you, Gustavo. I'm just sharing my slides, so hopefully everyone can see those on screen now. So thank you, everyone, and I'm delighted to join the panel with such esteemed speakers to talk a little bit about the changes to the introduction, indeed, of the Brazilian transfer pricing rules. I've been asked to give a little bit of external perspective. So what I thought this afternoon is, or this morning, is I would start off by sharing some of the UK experience when we introduced our own transfer pricing legislation into law. Moving on to talk a little bit about how HMRC applies the rules and what happens in the cases of breach and how we resolve transfer pricing disputes. And then finishing up with some concluding reflections on how the developments in Brazil could impact multinational groups doing business in both jurisdictions. So I hope this is what you're expecting to hear. Oh, now my slides are not moving forwards. Why is that? So let me. Okay. So, as I said, I was going to start this afternoon by talking a little bit about the experience of the UK. And I guess the starting point is to say that actually the introduction of the arm's length principle in the UK, well, it's been a feature of UK domestic tax law for a very long time. We only codified our transfer pricing legislation in respect of periods, after July 1999. But having said that, we've had the arm's length principle in anti-avoidance in various case law in UK domestic tax legislation since going all the way back to 1915. So in introducing the new transfer pricing, or the codification, if you like, of the UK transfer pricing legislation, and I suspect the experience will be very similar in Brazil, it's not a case of throwing out all the things that have happened in the past. It's very much a case of looking at the experience and the wealth of knowledge that's been built up over the years of, how to apply market values and how those market values are representative of the arm's length principle into a new set of circumstances. When the UK introduced the transfer pricing legislation, we did so against a backdrop where the OECD had developed an extensive wealth of knowledge as how the rules were to be interpreted. Indeed, I think the OECD, I was looking back, and I believe the OECD started thinking and documenting what the arm's length principle was back in 1979. So as we move forwards with the OECD style transfer pricing legislation in Brazil, you'll have that wealth of background and knowledge and guidance as to how the various principles should be interpreted. There's actually an express provision in the UK legislation which enables our rules to be construed in what's called a manner which best secures consistency with the arm's length principle as set out in the Model Tax Convention and the OECD guidelines for multinational enterprises. And I'd be interested to know whether there's an equivalent provision in the Brazilian rules, because the impact of that rule or that provision is to say, in interpreting UK legislation, you can have regard to the writings of the OECD in the guidance. The consequence, of course, of that is that in interpreting the UK rules, we have a body of experience and practice in the other countries, the other OECD member states that we can build on. in trying to determine what our rules mean. Possibly more importantly, in trying to establish what is an arm's length transfer price. And we have a body of comparables in other jurisdictions which we can refer to. We can look at, comparables in other that have been developed in other OECD jurisdictions, and to the extent that they're comparable to the transactions under review in the UK, we can develop what an arm's length principal price might look like, and use that in a UK context. So it doesn't have to be a purely domestic comparable. We look internationally at different comparables. And then finally, of course, there's a wealth of case law in other jurisdictions that give us the jurisprudence to develop our own interpretation of what our transfer pricing legislation means. In addition to the interpretive guidance that's sort of published by OECD and other jurisdictions, HMRC is excellent indeed at producing its own guidance for our own tax inspectors, and we have extensive guidance in the international manual as to how the rules should be interpreted, but more importantly, when HMRC will consider applying the rules, and I'll come back to that particular point in a moment. So then the final point on the slide is, and I'm sure the same is in Brazil, but this is the start of a journey. Whilst the legislation will be introduced, I think you'll find that it will evolve over time. So the enactment of the UK legislation, when it was first enacted, it only dealt with cross-border transactions. Over time, it has been changed to deal with the purely domestic transactions. And indeed, this year, in 2023, there's a change to make mandatory transfer pricing documentation an absolute requirement. So it is a part of our tax legislation that has evolved and continues to evolve, and we expect it to continue to evolve over time. So then, as I said, I was going to come back to, when does HMRC apply these rules? And I guess the start is the UK system of self-assessment. So the burden of proof is very much on the taxpayer. When a taxpayer prepares its tax returns, it's required to do so in a manner that is consistent with the transfer pricing legislation. So if you have a provision between affiliates which possibly doesn't comply with the arm's length standard, it is incumbent on the UK taxpayer to adjust that provision to ensure that it does reflect the arm's length standard when the tax filing is made. Then we come to the HMRC inquiry. HMRC, they adopt a risk-based approach in investigating non-compliance with the transfer pricing legislation. So there are various triggers, I guess, which more likely to facilitate an inquiry, and they won't be sort of triggers that are particularly of surprise to anyone. There'll be triggers like the counterparty on the other side is a tax haven entity or resident in a low tax jurisdiction. That's one of the triggers that HMRC will identify, and if they see that, they will potentially inquire as to whether a transfer pricing audit should be commenced. Other triggers would be things like, if there's a sudden change in the risk profile of legal entities. Those are the sorts of things that the tax authority will look to see whether there should be some sort of investigation. Cases then that are taken for investigation will be ones that potentially give rise to high tax. So is there a large amount of tax at risk? And also, is there some sort of complexity in establishing the arm's length provision? Because absent complexity, it's probably not something that HMRC would wish to pursue too significantly, because there should be an easy resolution. One thing I would say about the enactment of the UK legislation is that we haven't seen a lot of litigation in terms of what is the when we look at the substantive application of the arm's length principle, that's not something that the courts have been asked very often. And indeed, the first 10 years of our legislation, I think you'd struggle to find any case law relating to this substantive application of the arm's length principle. We had a couple of transfer pricing cases in and around the administrative, application of the rules and the scope of the rules. But it's not really until you get to 2009, 2010, I guess, that you have the first judicial cases looking at, what is the arm's length principle? How should it be applied? And I think that there are a couple of reasons for that absence of case law. The first is it's quite often it's difficult to confirm, what a transaction would be entered into between third parties dealing at arm's length, and confirming whether this is the same as the transaction that's been done between affiliates. So if I give you an example, you may have a group of companies that's developed an intangible or a brand, and it's not often that they will license somebody else to use that brand. So when you're trying to determine the basis on which affiliates should be entitled to use that brand, it's not always easy to find a comparable transaction which has been concluded between third parties. Second reason, I think that the courts haven't really looked too closely at the substantive application of the arm's length principle is the economic analysis that goes into these comparable analyses is often very complex. You've got your functional analysis, you've got your economic analysis, you've got it. The courts in the UK, we don't have a tax court per se, and therefore it's quite often the case that the courts and possibly the judges don't necessarily have the a wealth of experience or expertise to consider these cases. So I think historically, the way these cases have been resolved is through negotiated settlement between HMRC and the taxpayer. Obviously, there are cases that can't be resolved in that way, and we have the alternative processes to achieve resolution, whether they, are mutual agreement processes under double tax treaties, advanced pricing agreements, and in certain cases, we have had instances of joint investigations with 2 or more tax authorities into a particular arrangement. And then where there's, and I guess in that context, I would say, I note that UK and Brazil have included a double tax treaty. It's not yet in force. It has to go through the legislative process in both jurisdictions. But there is a double tax treaty, and therefore there is potentially the prospect of MAP proceedings in the future for taxpayers in the 2 jurisdictions. Then on the right-hand side of that slide, just illustrating, if there is a resolution that concludes there has been a breach of the rules, there could be a one-sided adjustment. There could be a two-sided adjustment. One-sided adjustment, generally not great for the taxpayer. Bilateral adjustment, probably better for the taxpayer. I've thrown in there multilateral adjustment because, of course, the way multilateral groups operate these days, you quite often see global trading arrangements where an adjustment in one country could potentially give rise to multiple adjustments all over the world. So important to think of, if we do have arrangements in place where we need to make a transfer pricing adjustment, there could be implications in one or other jurisdictions. And then, of course, interest and penalties to the extent that the breach is caused by negligence or gross negligence. So I was going to conclude just by having a look at continuing compliance, as it says there. So if I think about the way the rules operate today, quite often, Brazil has a shall we say, a more prescriptive rule which allows greater certainty. But as the slide says, there's a risk that the Brazilian rules results in a transfer price which is higher than what would be the case under an arm's length range. So multinational groups today are complying with transfer pricing legislation in both countries by adopting the Brazilian transfer price, which is potentially higher than the arm's length principle, and therefore satisfying transfer pricing regimes in both jurisdictions. The complexity, of course, going forwards is, as Brazil moves away from the more prescriptive rules to a more of an arm's length type rule, if they have a preference for one rule over another, you may find that, for instance, the UK prefers that people use the cut method because it's the simplest and often it's the most accurate. But we also we accept that it's quite often it's difficult to identify a comparable uncontrolled price in practice, and therefore HMRC quite often accepts that some sort of profit-based method like a TNMM or a profit split is often more appropriate. The risk, of course, is that if Brazil insists that we apply some sort of cap, that cap needs to fall within the same range as applied by the overseas tax authority. And I guess the concern is if and to the extent the cap delivers a price which is outside the TNMM range, then we need to understand why and as appropriate make adjustments. The problem, of course, with making adjustments is, a cup is a cup and it's great, but as you make conforming adjustments to conform the transaction to the actual transaction between the counterparties, you quite often find that the robustness of the cup price comes under question and potentially is prejudiced. So I was going to conclude there and pass over to my esteemed colleagues. The only final comment I would make is that it's a very exciting time to be doing business with Brazil, because I think when there are changes of the magnitude that we're seeing today, both in terms of corporate tax, in terms of relations with overseas countries, and in terms of the transfer pricing legislation, it's always interesting in those times of change to see how things develop and how things evolve. So I think this is a great opportunity and a very exciting time to be doing business in Brazil. Gustavo, I was
Thank you very much, Tim. Yeah, thanks a lot. Thank you. Thanks for reminding us, as you did in the beginning of our presentation, that this is just the beginning of the journey for Brazilian tax practitioners and tax administration on applying these new rules, as it was a journey for the UK as well. And yes, lots of thrilling developments ahead, if we're optimistic about them. So moving ahead, shall we have Márcio, Francisco, up to you guys. How do you want to go forward with it?
Okay, Gustavo. So thank you so much for this opportunity. So I'd like to, before I think, say thank you for you and to the BBC board for this invite. And I'm very happy to here to share a little bit about our practice experience with transfer pricing, and share what we are discussing and we are hearing from the Brazilian IRS. So I think that, so as King said, so we have a great opportunity here in Brazil involving transfer pricing. We need to keep in mind that the good thing is that the Brazilian tax authority make clear that we will follow the OECD guideline. In other words, we have a full alignment with the OECD standards. That's a good thing. Of course, we will have probably some tropicalizations. Okay, it's usual when we're talking about Latin American countries. We have something like this in Argentina, Mexico, Chile, and Brazil will tropicalize some aspects regarding the OECD guideline. But we do not expect surprise in this direction. Okay, we need to keep in mind that the Brazilian IRS has a responsibility to match the Brazilian the OECD guideline with the legal tax rules that we have, that internal tax rules that we have. Okay, that's one concern that we have here in Brazil. One other challenge that we have here is that we, in fact, are changing the Brazilian transfer pricing rules. However, we did not see yet changes in some correlated rules. For instance, customary rules, taxation or remittances, taxation under internal external investments of Brazilian multinational companies is something that we need to evaluate. But we are discussing this with the Brazilian IRS and we are in a good way in this direction. So I would like to share here. I will share a quick presentation that I prepare, so when we can go ahead. Can you see my screen? Yes, great.
Yes, it's perfect. Thank you.
Here we have an overview about the main change that we have in our TP rules. So We have an expansion of related party concept. So for a long time, we have an exhaustive list of concepts of related party concept. And however, from now on, the concept of related party will be based in principles. So and will be full aligned with the OECD. We introduced some concepts about comparable transactions. It's fundamental. We expect that the Brazilian IRS will rule this aspect. We expect for the end of September normative instruction about this topic. The concept of tested party, it's here we could have one important point for discussing. Because what the Brazilian IRS is saying about tested party, they are following the concept, the OECD concept about this. What is the OECD company? The tested party is the party that has low risks, functions, and assets, and the part that have the more reliable information. Okay, that's an important point. However, we have some concern about that because from a Brazilian IRS perspective, which part has the more reliable information? Probably will be the Brazilian party, because the Brazilian IRS has access for those information based on the forms that the taxpayers send to the Brazilian IRS. This point we need to observe in the future, because here we could have a risk of that the related party, that the tested party will be always, or in most of the cases, the entity in Brazil is something that we need to observe. But from a theoretical perspective, we have a concept equivalent that we have on the OECD guidelines. Okay, of course, we introduced the risk and functions analysis, the FAR analysis, so it's fundamental from a transfer pricing perspective. But here, I would like I could talk about most of those topics, but we do not have sufficient time. In this direction, I selected two specific points to discuss: commodities and intangibles. Why we select commodities? Because the importance of commodities to the Brazilian economy. When we put on the paper the numbers regarding our exports, we can see that commodities represent most of our commercial balance in Brazil. And intangibles. Why intangibles? Because for a long time, the Brazilian TP rules did not keep focus on intangibles. So we have a lot of intangibles below the line water that we need to evaluate the transfer pricing from now on. Okay, I will jump to the next slide to talk a little bit about commodities. So what we have here about commodities. I think that one important point here is that Brazilian IRS make clear on the law and in the normative instructions draft that you have today. They make clear that probably for commodity they will prefer the cup method. Okay. It's not something different that you have in other countries, but here I would like to remember what the king said. So in some circumstances we could have a mismatching, considering the Brazilian IRS point of view and the point of view of the other tax authorities in other countries. Let's take an example. Let's imagine that we export a specific commodity to a trading company UK, for instance. So from a Brazilian perspective, the Brazilian IRS will probably request the CUP application. Okay. However, when the tax authority in UK test this transaction, probably they will apply the TNMM for the trading company abroad. So in this case, we can found different results for these transactions. So it's something that can create problem to the taxpayer, and something that we will need to discuss in the future. Okay, the Brazilian Tax Authority is open to discuss the TNMM. However, to the TNMM application from a Brazilian perspective, the taxpayer must be able to show that the copy does not work well. Okay, the taxpayer needed to put together information, documents, to provide elements to the tax authority to show that the copy is not applicable for any specific transactions. Okay, so we expect some that the taxpayer will be challenged about in case of TNMM application, but it's something that we need to observe in the future. Regarding the application of the transfer pricing in Brazil to commodity transactions, one other critical point is regarding the date of the transaction. Okay, because the Brazilian tax authority is designing a system, okay, to the taxpayer inform in advance the date of the transaction, okay, and what the Brazilian tax authority wish, what's the dream of the Brazilian tax authority in this case, is that the taxpayer informed by a parallel system using documents, agreements, etc. The effective aspects regarding the transaction. For instance, date, type of product, conditions, etc., etc. It's not clear how it will work, but the Brazilian IRS will follow this way. It's something very similar that we have in Argentina, for instance. So in Argentina, the taxpayer needs to inform in advance the criteria related to the exports regarding commodities. Okay, it's not something new. In Uruguay, we have something similar, and probably will follow this way. Other important point regarding commodities is that the Brazilian tax authority will challenge the trading structures that we have today. Most of our commodity exports is involving a trading structure in other jurisdictions. Okay, the Brazilian tax authority will keep focus on that, especially challenge the substance of those entities. Okay, to evaluate if it makes sense to allocate profitability on those entities abroad. So it's something that you need to keep in mind. So basically, for commodities, I think that the main challenge that you have is that other important point is regarding the criteria of comparabilities. Of course, we know that let's take an example. Let's take an example of oil exports. We do not have a well specific that produce Brent. Brent, in the end of the day, is a fiction. It's a basket, a combination of different types of oil. Okay, and naturally, we do not have the oil exported by Brazil will not be identical to the Brent. So the Brazilian IRS needs to make clear what kind of adjustments and what kind of adjustment they will accept to make different type of oils, minerals, agro commodities, to make those transactions comparables. Is something that you need to evaluate. So I think looking to the future, we have those challenges. But we need to remember that Brazil is one of the most important commodity exporter. So I believe based on that in few years we will won those challenges, and probably Brazil will become reference in transfer pricing for commodity. Okay, because we apply this a lot. Okay, it's not something for 1 year, 2 years, but I believe that within 5 years, 10 years, will be referenced in this direction, because we will apply and we need to apply a lot this kind of approach to intercompany transactions. Okay, so jumping to the next slide. So I would like to talk a little bit about royalties. So for a long time, we have limitations to the royalty payments in Brazil. Basically, the taxpayer could had a deductibility equivalent to 1 to 5% of the total income in general. And the agreement related to royalty must be subjected to the INP analysis. INP is National Institute of Industrial Property. So we had for a long time limitations and bureaucracy about the royalty payments to other entities abroad. However, taking in consideration the new TP rules, here we have an avenue of opportunities, because from now on, the royalty payments, the deductibility of royal payments will be tested based on the arm's length principle. So once the taxpayer has a TP study, and so this TP study will provide the limit regarding the royalty payments. Okay, and one good thing regarding the royalty payments, when we compare, for instance, with when we compare royalties, for instance, with the intercompany services, is the taxation on the remittance. To the royalty payments, we have basically withholding tax and seed. The tax burden over the royalty payments is equivalent to 25% in general. So it's lower than we have, for instance, on services. For services, depending on how you manage your agreement, you could have a tax burden equivalent to 40-50% of the total amount that you are remitting to other jurisdictions. So here we have an opportunity: pay more royalties and pay less intercompany services. The taxpayer that will be able to make the shift probably will take advantage of the new TP rules. It's something that I recommend to evaluate in this discussion. Okay. And to take advantage of the full possibilities involving royalties, what we recommend is to perform a TP assessment to identify what kind of royalties the Brazilian entity is able to pay. So you can pay royalties related to trademarks. You can pay royalties related to technology and processes. So a TP assessment will provide you an overview about what kind of royalties you can pay and take advantage of the new TP rules in this direction. And connected with this, so other important point is regarding the intangibles. So the Brazilian IRS said that they will keep focus on intangibles, because the Brazilian tax authority understands that for a long time we have shifting of profitability based on intangibles. So we shift to other jurisdictions and assets, risks, and functions. And Brazil was not remunerated for that. From now on, the Brazilian tax authority will keep focus on intangibles, and in these directions, a depth analysis is fundamental to understand the value of those intangibles, and to decide how you remunerate those intangibles, if it makes sense to shift these intangibles to other jurisdictions or not. So it's fundamental to perform this depth analysis. Okay. Here we have, in this context, we have an interesting thing, because when you're talking about business restructuring, when we have a business restructuring involving Brazil and other jurisdiction, we have a shifting of intangibles from Brazil to other jurisdictions. So in this case, what we recommend? We recommend, if one entity intend to perform a business restrictions, do that this year and postpone the adoption of the new TP rules for 2024. Because if you perform your business restructuring this year, and you decide for the adoption in the next year, those transactions will not be subject to the transfer pricing based on the new TP rules. So it's one point here we can one point a possible the entities can have a possible point of savings. Okay, so if you perform your business restructuring the next year, those transactions involving shifting of assets, risks, and functions to other country will be subjected to the transfer pricing. So it's better to perform now and postpone the adoption of the new TP rules to in 2024. Okay.
Marcel, would you please invite you to conclude?
Yes. No, it's just it, Gustavo. So thank you so much, and let's go ahead.
Oh, fantastic! Thank you for such a pragmatic advice. It's very clear that you already identified not only the challenges but the opportunities of the new legal framework for TP we have in Brazil right now, and that's precisely what businesses should be aiming at this point. So, without further ado, Francisco, would you please take the mic?
Yes, Gustavo, thanks a lot. I'm not sure if everyone is looking at my screen right now, but I hope so.
Yes, it's there. It's clear. Thank you.
Okay. So first of all, I would like to reinstate my thank you to Gustavo and to all the members of the Brazilian Chamber for this kind of invitation. And I would also like to congratulate Kim Allen and Márcio Oliveira. Both are very close friends and professionals, which I respect a lot. And it's an honor to speak right after them. So without further ado, following on the line of thoughts that Márcio and Kim have presented, I have just prepared one slide here, and I'm going to comment on, as a lawyer, on my concerns regarding the application of the new transfer pricing regime in Brazil, especially given our difficulties regarding the mindset of the tax authorities and what is foreseen in the applicable legislation. I have selected as an example the issue regarding the financial transactions. So first of all, let's talk about this new concept that we have. It is not new to transfer pricing practitioners, but it is new to Brazilian tax practitioners, which is the accurate delineation of the transaction. And we've had discussions on this case for a very long time, yet since as an example, when we had the change in the accounting rules here in Brazil in 2007, if I'm not mistaken, a lot of many discussions regarding the form of contracts and the actual substance of the transactions took place, and its tax effects, they are discussed since then up to today. So now we have these new discussions coming into the tax territory and the transfer pricing territory. For example, we have the discussion on the delineation of the transaction. Regarding financial services, and actually regarding the whole transfer pricing legislation, we do have Article 2 and Article 3 of the new law, which require us to look into the actual conduct of the parties in order to determine its tax effects. So we have to take into consideration not only the contractual terms, but the specific characteristics of the goods and services being provided, the economic circumstances, and the actual business strategies. So this is something that brings many concerns to us lawyers and tax practitioners, because we are going to have a landslide of challenges by the tax authorities, because they are going to look into contracts that have been in place for many, many years, and for conducts that have been engaged by taxpayers for many, many years. And now they are going to look into those conducts, and they're going to reclassify in order to supposedly align those conducts with the actual substance of the transactions. I have to go back a little bit and explain that on the issue of financial transactions, Brazil has been a country which has also adopted what we call the fixed margin approach. And since 1996 up to 2023, we've had the approach of, in 1996, we had the acceptance of the deduction of interest when the contract was registered in the Brazilian Central Bank. And that was it. It was so because the Brazilian Central Bank would supposedly conduct an administrative review, and if the amount of interest to be paid by the Brazilian debtor was supposedly excessive, they would require a review of such interest, just like the INPI was supposed to do with royalty contracts, as Marcio just mentioned. But then in 2012, we've had a very significant change. And then Brazil changed Law 9430 in order to consider that the Brazilian Central Bank was not anymore conducting such administrative review. And then they decided to basically include three possibilities, which was going to be loans denominated in reais for a predetermined rate. Then we would follow the rate of the Brazilian sovereign bonds added by a 3.5% spread. That was the maximum amount a Brazilian debtor paying a loan in reais would be able to pay. Then if the loan was denominated in US dollars with a predetermined rate, then we would look into the Brazilian sovereign bonds rates in US dollars added by a 3.5% spread. And finally, if the loan had a floating rate, then we would have to look into the LIBOR plus a 3.5% spread. So it was very easy at the time for a company to get a loan overseas and basically re-transfer the loan to the Brazilian entity. And with this arbitrage, such company would be able to pay a very small interest rate, interest on such loan, let's say in Europe. And then in Brazil, the Brazilian entity paying the loan abroad would pay a much higher interest rate. And it was okay, because the Brazilian tax authorities, they were privileging the tax certainty and the fixed margin approach, and they wanted to guarantee that a minimum rate would be accepted. But now we have this substance over form approach, and we have the transfer pricing guidelines being considered as a secondary source of guidance in Brazil. The draft of the normative instruction that was issued recently was mentioning that the transfer pricing guidelines would be viewed as a secondary source of interpretation. And the 2020 guidelines, they mentioned whether a loan should actually be regarded as a loan. So we are going to look now into the realistic available options. And if the debtor, for example, has a solid financial position, was he actually supposed to take a loan, or is it actually equity and a reclassification should be regarded? This represents a strong change in the mindset, and I take as an example the Brazilian CARF. For those who are not familiar with this concept, the CARF is the Brazilian Administrative Tribunal, which is actually I can say that it's the main tribunal, the main administrative tribunal to discuss facts in Brazil, because they go deep into the accounting and the documentation of the cases before we actually go to the judiciary. So in this case, the first case that I want to mention is the Colinos-Colgate case. The Colinos-Colgate case is a case in which the CARF decided in favor of the taxpayer, even though the owner had a 99% equity of the buyer. And the owner granted the loan instead of capitalizing the entity to make the acquisition. Not to go deep into the case, but it was actually the case in which if we had at the time a fin capitalization rule in the law, it would be resolved. But then at the time, the CARF decided that Brazil did not have a fin capitalization rule, and this strongly debt financed acquisition was okay under the law at the time. And some jurists, such as Alberto Xavier, the late Alberto Xavier, which we learned a lot from him, he explained that this was one of the cases which inspired the Brazilian Congress to enact Law 12.249, which is the law of the fin capitalization rules in Brazil. But then we have the fixed margins adopted by the fin capitalization rules. And let's remember, if you are not domiciled in a tax haven, if you are in an actual tax country, which taxes income with effective tax rate over 17%, and you are not, you do not have secrecy of shareholders and everything, then you can borrow, you can lend to your Brazilian subsidiary 2 times the equity. And this is a fixed margin approach. Under this rule, which is still in place, you can basically lend as much as you want, and you can still deduct all the interest should the interest be deemed at arm's length approach. My critic here, what I'm criticizing here, is that the Brazilian fin capitalization rule was not changed actually under the new legislation. So we still have the fixed margins for the fin capitalization rule, even though we are now adopting a substance over form and the arm's length principle application. So in this case, it's like I was supposed to be reforming my living room, but I forgot to paint my wall. In my opinion, I don't know the opinion of the other experts in this panel, is that the Brazilian fin capitalization rules should also be reviewed in order to maybe drink from the international experience and amend it in order to have EBITDA approaches and sector approaches, because we know there are some sectors which you are allowed to take a higher level of debt, such as the financial sector. And then we have another example, which is Usina Barra Grande case, in which the taxpayer was issuing debentures and those debentures were acquired by another company of the group who had a significant amount of tax losses. And in that case, the case was decided under the substance over form approach, because actually the debenture should be requalified as equity. That was a Brazilian to Brazilian case, but it explains how the CARFA is going to view cases like that for the near future. And
Francisco, please invite you to conclude your comments. Thank you.
Okay, no, my final comments is basically because then we have actually Article 36 of the new law, and in which the tax authority is going to conduct a tax inspection. And at the end of that tax inspection, it will grant some time for the taxpayer to review the adjustment proposed by the tax authority and pay it with just the late payment fine. So in this case, I see an actual higher power for the tax authority in order to enforce its position rather than discussing how the substance over form approach should be applied. So with these comments, I finalize my presentation, and I hope everyone, well, I'm available for the questions and comments afterwards. Thank you.
Thank you very much, Francisco. And you made very important points precisely on how do we all deal with this new reality in which a transaction formalized as a loan may no longer be taxed as a loan. And as Marto pointed out, an exportation of commodities to a trading may no longer be taxed as an exportation of commodities to a trading, depending on the analysis made by the revenue on the effective functions and risks being taken by the trading in the relevant transaction. So yes, and as always, we finalize our webinars in the tax committee with a Q&A session. Today, we don't have many questions to address here. One made by Carlos Hang Advogados. Is it possible to provide services between companies in the same economic group? Yes, for sure. I'm answering that already. It is possible for a Brazilian company issue an invoice, a services invoice to its parent company in the UK. And yes, what we're discussing here in this event is precisely whether taxation of that transaction shall be subject to rules that determine whether the profit acknowledged by the Brazilian company when rendering services to a related, an affiliate, or in this case, a parent company abroad, how the amount of profits in this transaction is subject to determination as a result of the transfer pricing rules. Yes, I would also add another question specifically to Francisco, and a quick one. On your last point, the last point that you made about Article 36 of the new law, the discretionary powers granted to the tax administration. In short, my reading of that provision is that the administration now has a bigger stick, namely that if you taxpayer behave in a way that I hold it nicely, I apply a lower penalty. Otherwise, I'll apply the higher penalty. It's up to you to decide, right? What's your feelings about, and specifically, what's your feelings about how the judiciary power, how the judiciary branch in Brazil will see a piece of legislation that in practice that allows the administration, the tax agent herself or himself, decide which is the penalty applicable to the case?
Yes, that's very, well, if I had a crystal ball, I would be able to answer, because what I think it's right is actually that a taxpayer which has not hidden information and has basically complied with the requests of the tax authorities should be able to receive a lower penalty. But we never know how much, for example, we have the discussions of the goodwill deduction in Brazil, and some tax inspectors they understand that the shelf company that is basically created to make the acquisition, and then you have the reverse merger in order to merge the shelf company into the acquired entity and to allow the deduction of the goodwill in the acquired company. That is an abusive transaction. It should be receive the higher fine. But in my opinion, the law states that it's okay to do so. And it's, again, a substance of a form discussion. So situations like that are going to arise much more often with this concept of delineation of the financial transaction. And a tax authority is going to look into a transaction and say, this is not a loan, this is equity, you are abusing, so please take the higher fine. Situations like that are going to emerge much more often. And going back to Mr. Hank's question, the possibility of providing services in the same economic group, we can see whether or not those are services or if they are what the OECD guidelines mention as low value added services, or what we call here in Brazil, the sharing of administrative costs by the headquarters. And this is the topic of a whole different webinar that we could make in the future, because this is something that will raise many, many questions as well.
Francisco, it's a great idea. I totally accept the idea. Let's aim for this new event, a new webinar of the tax committee addressing this specific discussion about the cost sharing agreements versus low added value services versus services in general. And I would add to that royalties as well. The point that Marcio made about the new rules having a very strong impact on how the taxation of intangibles and patents and those kinds of assets may bring about a new way of rethinking relationship between affiliate companies worldwide. And with that, trying to keep the time that we have agreed in advance. I thank again Kim, Marcio, and Francisco for sharing your knowledge and your time with us today. Thank you for the very elucidative remarks. And Vera, would you mind ending our discussion today?
Oh, sorry.
There you go. There you go.
Yeah, no, I don't mind at all. It's actually a pleasure. It's a final word just to thank you all very much for being here with us today. It was extremely informative. For me, I'm not a specialist on tax law. It was extremely informative. So another great event of the Brazilian Chamber, and thanks to you. So thanks a lot. And see you next time, and soon, I hope.
Gustavo, you're muted again, Gustavo.
Sorry, just thanking everyone. Thank you. Thanking everyone that joined us today, and hoping to see you all next time. Thank you. Take care. Bye.
Thank you. Thank you. Bye-bye.
Thank you, everyone. Bye-bye. Bye-bye.